You're listening to the Valley Current.
Jack? So how are you?
Pretty good. Yourself?
Thank you. Thank you. I'm fine. So I see you, you see me, everything's working. Well, this is all, copyright is a mess. The law is a mess. It's incomplete. As you have said, it doesn't really address what we've got going on today. It will have to be legislated or forgotten. It's not, I've never liked the term intellectual property. It's not property. That bugs me. I don't see how what we have advances science and the useful arts. It's more like commercializes creativity wherever it shows up. It's all a mess. And yesterday on Friday, reading to prepare for this, I looked again at the statutes, 107 U.S. Code, etc. What is it, 500 pages long with 80 million definitions?
Yeah, I should say, if you look at the history of copyright, it goes back to the United Kingdom. And
when do you place it in the United Kingdom?
Well,
when?
I would say it probably started sometime in the 1500s, right? 1600s?
Probably after Gutenberg, after the printing press.
Right.
But the idea of copyright might be later even than that.
Well, and I want to tie it to, in the U.S., we had an act. Well, we have the constitutional provision that authorizes it. Then we have an act. Then we have a revision in 1909.
Right.
It really stays static until 1976. So literally almost 70 years later. And the 76 Act didn't really become effective until 78.
Right.
And then we had a software copyright amendment in, I want to say 1980.
The DMCA?
No, that's later. That happened.
That's later.
That happens later. So if you look at what's happening, it's like we have this body of law that changed every 50 to 70 years, and then started to change maybe more like every 20 to 30 to 40 years. And now it's starting to be it's got to be updated almost every decade, or maybe even more often than that. I mean, I hate to say that Congress would actually have their finger in this every decade, because every time they do something, it generates a lot of controversy and a lot more litigation and a lot more appellate litigation. But we haven't really had anything dealing with AI per se, or any of these innovations for since really forever.
Well, my view is the AI phenomenon emerged late last year. Before that, it existed and it was thought about, but it didn't really produce product. No AI product that I'm aware of existed before 2021.
Well, yeah, because if you look at kind of the history of the way client-server computing went, it used to be everything was on your local disk. It wasn't on some central server. We pushed away from the centralization model back at the time that Apple Computer and other microprocessor companies were saying, hey, we want to break down these mainframe centralized computers. We're against it. We want to decentralize. And now it's completely flipped back to this centralization where a few big players, whether you call them, Google, Amazon, Microsoft, Apple, Meta, Facebook, and so on, they're big players. They've got control of a lot of data, and there's a lot of other data that's out there. Of course, it's a huge internet. And once you start scraping it on the assumption that, there's ideas that we want to farm, just trying to be neutral about this, we're entitled to get to the ideas. Of course, we have to figure out how to get to them without taking advantage of any expression, and where that line is between idea and expression. And can you furrow through all this copying to get to the ideas to begin with? on some view that, hey, there's all these licenses and shrink wrap agreements and other stuff.
Right.
Obviously, the cases are going to have to deal with a barrage of arguments that are designed to say, we don't even think you should get to the ideas. We don't think the ideas should be accessible, even though you could argue that once it goes up on the internet, it's published, it's not trade secret, it's not protectable. The idea is in the public domain unless it's subject to a patent. And of course, patents haven't really covered ideas per se. They cover particular inventions or implementations of ideas.
And scraping, it may create transient copies, but the result is not a copy. The definition of copy is in the code, 27 US code. You know, it is all a mess. In reading the complaint again, maybe their strongest argument to me is the website agreement, the usage, the terms of the website. That may be the thing that's being most obviously violated. But of course, it's not clear that those terms are legitimate.
Yeah, I mean, let's just look
Google Images.
Let's just look at the two cases we're talking about, because they're both targeted against Stability AI, and one of them actually has multiple defendants.
Correct.
But if you look at what's happened in the big picture, and I date it back to when music first started to be shared online, that was the beginning of, hey, this stuff is online. We're going to be able to accumulate it. We're going to be able to share it. And of course, some great businesses went down in flames of copyright litigation because they thought they could do it without a license and without permission. Apple and Steve Jobs, bless his soul, was smart enough to say, no, I'll actually negotiate a deal and I'll be a brand that isn't, basically a label. And I will make sure that the player works really well. And I'll make sure that the player software works really well. But the very first company that came up with this file sharing program got destroyed in litigation. Digital content is there online. You can get access to it. You can share it. You can do something with it. And let's see if the authors and songwriters and the rest decide to do any litigation. Let's wait and see. Let's break some glass here and change everything, because it is very much like changing the entire music business. And it did. It did change the entire music business, right?
What was the first company you were mentioning?
Oh, I'm trying to remember, the device was called the Rio. The Rio was connected online through a Napster. The file server company was called Napster. The litigation was called the Napster litigation. I want to say Judge Patel, who was the chief judge in San Francisco, chief federal judge at the time, made the rulings, and she was a very big proponent of copyright protection. And she made some devastating rulings against them, and basically they were forced out of business. But they were the basis of the innovation that is now really Apple Music. I mean, if you want to trace the innovation of, if you can put it online and you can store it on a computer, you can basically get access to it, and then Apple Music lets you authorize it with an appropriate micropayment to them, or maybe now they have a subscription model.
But they pay the composer, they pay the owner of the copyright.
Right. They do it in a legitimate way because Judge Patel set a ruling that made it pretty clear that you had to negotiate. But those negotiations are far easier because there are these big publishing companies that control a lot of the music. In the area we're talking about, with the exception of course, the case that's Getty Images versus Stability AI, which is in the federal district court in Delaware and is now mired in a bunch of procedural litigation,
right?
Including whether that case gets transferred to California, which I guess Stability thinks the Ninth Circuit is a better place to be than the federal. It won't be the federal circuit. It would probably be I think Delaware is technically the third
Delaware. I think Delaware, they recite it being a Delaware company and explain why jurisdiction is appropriate there.
Right. But the Court of Appeal would be probably, I think, the Third Circuit for Delaware.
Right.
I think Delaware goes to the Third Circuit. I don't think it's in the Second Circuit. I should double check that.
Okay. But are they? I asked the first question: is it copying? Scraping and copying are two different things, and every human being is doing scraping just by looking at art. And by the way, there are many different kinds of images that are complained about. The complaint of Google Images versus Stability AI is complaining that the collection, the collection or the compilation that Google Images offers the world for a fee is being competed with by the compilation that Stability AI offers the world. You can go to either compilation and say, I want a picture of a dog with a hat. And, Google Images has its picture and Stability can create its picture. So Google says they're competing with us. They're infringing on our market, which is a little bit strange because nobody really is copying any of Google Images' single images, except in some cases. In some cases, they are copying specific images, and you can recognize what the source image is. But in many, you can't. Junko, my wife, is entirely collage. Every one of her works is created of tiny little pieces that she cuts out of other art images, and then she puts them together. And she asked me, am I infringing copyright? I've always told her, no, it's transformative.
Right.
Nobody could possibly recognize the source of this tiny little 1/4 inch fragment. And your work is completely different. But it's getting very interesting. It's legally interesting, and I don't know what I would do if I were king. Would I tell them no more copyright? It's all public domain once you put it on the internet? I don't know.
Yeah, I mean, that's the extreme position in favor of what might be called ideas and their dispersion trump everything, which is once you put something on the internet, you're effectively saying there's a free license to do whatever you want with it, so long as you include attribution. Kind of a notion of an open source license. I'm not giving up the copyright. It's not in the public domain, but I am asking for attribution because I want to get some credit for the work. There's not really an attribution system baked into any of these AI tools. It's almost they want to hide it, right?
Yeah, they don't carry the metadata. But the owners of the copyright want license fees. They don't just want attribution. They want money. And it's the commercial potential of what they've done that they want to preserve. And
right.
That's what's interesting.
Right. Let's say that attribution was tagged. That would create a very nice evidentiary record for actually calculating some type of fee, because you could argue if attribution is required, and there are causes of action in these complaints that suggest the, quote, copyright management information, the copyright notice, should be reproduced as a required element of anything that's done. So if you took the view that, look, there's some de minimis copying, maybe some of my work, maybe some of your work, maybe some of your wife's work, it's just not copied enough to be actionable. And then, but you could trace it. You could basically go online and say, how many instances have there been? And once it hits some magic number, maybe then it becomes royalty bearing. Because if you're Getty Images, you probably will let people get away with a little bit of copying to just say it's de minimis, but maybe not. Maybe on some photographs, they're just too valuable to let even a single instance go by. But I can see a middle ground that goes more like it really depends on the volume of copying.
Well, I think it depends on two things. It's the volume of copying of a particular image, and it's the number of images involved. To copy 3 images and put them into my work is one thing. To copy 3 million images and move them around and then create my work, totally different. Of course, the artificial intelligence process begins with a prompt and ends with an editing session. So I could make a prompt, give me 100,000 images, and I'll make one that looks like, Andy Warhol. And when it comes out, I'm going to edit it for 3 days to make sure it looks more like Andy Warhol, even though it came from 3 million images. There's all those different styles of artificial intelligence image generation. It's very, very hard to put your arms around.
Well, I was going to go the other way on your point that you edit it maybe to make it look less like Andy Warhol. So let's go the other way for a second, because there's a Ninth Circuit case. I want to say it's C versus Durang. That's what the back of my mind says the title of the case is, where the Ninth Circuit says, look, if someone starts with a copyrighted work, whatever it is, and does a bunch of editing, whether it's text, whether it's video, audio, whatever, they just do a lot of editing, it could transform into something that's quite different and not subject to infringement, not subject to a derivative work argument, kind of like you ended up with the idea. You ended up sort of boiling the thing down to its essential idea and then recasting it in a way that does not include any protected expression. And people have time with that, because people are like, well, if you started with my work and it inspired you, and then you started to play with it and edit it and so on, well, aren't you getting some head start? But it's not a head start. It's really not a head start trade secret-like concept. It's much more of a, where does the line exist between the Golden Gate Bridge, which is in the background, and then someone remodeling that in a way that just looks like a completely different bridge, completely different structure, completely different color, completely different theme, right?
Right.
We see this often in superheroes. I mean, how many different Supermans, Batman, Spider-Mans, Ant-Man? I mean, you can go down the list. They're all superheroes. They all have a costume. They all can fly. They have certain powers, but they're all transformed in a way that Superman can't get the royalties on. And maybe Superman took advantage of somebody else before Superman, whatever that guy was.
Well,
Gordon, right? Flash Gordon was one of the first ones, wasn't he?
Right. So what will the court possibly do? You know, and this really, there's so much going on in the Google Images versus Stability case. To me, copying is a big question. Copying one image, scraping one image, or scraping one artist's images versus scraping 3 million images is very different and less infringing, in my opinion. I think though, and then transformative use is another whole issue, as you've said. You know, one of the 4 categories is, does it infringe the market commercially? Yes, it does, but not any particular work. It's Stability AI's whole enterprise infringes Google Images enterprise. That's what it seems to me.
What I wanted to do, but I don't know if I'm going to be able to do it because I don't know if this machine is, well, so be it. I wanted to play this screen share of what the Stability AI CEO says publicly, because to me, if you're litigating this case against Stability AI, you have to have a group of lawyers or paralegals go through every instance in which he goes on YouTube or he goes on Facebook. I mean, he is a huge public presence, and he likes to say the world is changing and you just can't stop the locomotive that is in process here. In other words, we have this unbelievable locomotive that is going to completely change the way creation is done, and you just ain't going to stop it. You just ain't going to be able to stop it. And there's nothing you can do about it. There's really nothing.
There are no programmers in 5 years. Wow. I think we always have to look at the unchanging versus the inevitable. So an inevitable is 41% of all code on GitHub right now is AI generated. ChatGPT can pass the GLUE level 3 programmer exam and it will run pretty much on a MacBook or
and that's this year.
This year, right now.
Yeah. So those of you with kids who you are having Python lessons and so forth, maybe it's instead helping them to understand how to ask great questions or give great directions or prompts.
There are no programmers in 5 years.
Wow.
I think we always have to look at the unchanging versus the inevitable. So an inevitable is 41% of all code on GitHub right now is AI generated. ChatGPT can pass a GNU level 3 programmer exam and it will run pretty much on a MacBook or
And that's this year.
This year, right now.
Yeah.
Now it's got to the point where this technology could potentially be dangerous. As we scale more, we don't know exactly how it works. And so I'd love for them to be responsible to have
more open.
But not everything needs to be open, but we do need to be transparent and careful when stuff gets out of our control. In their own artificial general intelligence document, they say, we believe this technology could be existential and we will treat it as such. So in that case, you should be transparent and you should be extra more than anyone.
So the reason I showed that is, imagine that he has to be transparent. He's the CEO of Stability AI. Someone's going to make him eat his words and say, you've got to be transparent about what the hell are your algorithms doing to all this data that you are generating? Because there's a lot of data that you're taking advantage of. And you've admitted in various places that you're scraping the entire internet, no limitations, just basically scrape it all on a continuous basis, 7 by 24 by 365 constantly. And then you're allowing the creators, if you want to call someone that generates various prompts a creator, I would, but maybe other people wouldn't. And then you're letting them take advantage of that output in some fashion without paying a royalty. The view of life is, well, no one has said I can't do it, right? There's nothing specific in the Copyright Act per se. Now you could say, well, of course it's not specific. It talks about registered works. It talks about infringement. What?
And this isn't infringement.
Yeah,
that's an important point. Now,
I'm sure they must have an opinion of counsel from some big law firm to try to protect against the willful infringement arguments that say, look, what you're doing is you're extracting ideas and principles. In fact, he says that in one of his speeches. He says, part of what we're doing is we're trying to extract principles. We're trying to extract what's the underlying principle to what is actually going on here. Now, I don't know if there's any real truth to that they really are somehow just focused on principles. I mean, if you were doing some sort of clean room approach, how would you decide where a principle starts and an expression, or principle ends and an expression starts, right?
Right.
I mean, here's what he said on Instagram, which I was trying to show, but I don't think it was.
Big human scale. Basically, classical AI was all about taking stuff and extrapolating it. What we've done is we've trained these things on large amounts, like huge amounts of data to understand principles. And now when you use a GPT-4, it's like a really talented intern analyst with a bad memory. And we're about to fix the memory. And it knows how to pass the medical bar exam or medical licensing and others. It knows how to draw beautiful pictures or create audio of any type. And it's basically available to everyone for pennies. And so we have to think, what does that mean? It can mean huge disruption, or it can mean basically we're at the point of utopia and abundance. We have figured out how to make humans scale.
I mean, that's his theory, right? Basically, This is an innovation, not unlike the personal computer, the word processor, the spell checker, the grammar checker, all the things that professionals use in their writing and their creation. The computer-aided design that's been around for a long time, the drawing packages that have been around, and they're amplifying talent. But now the amplification has really gone to the next level, to the level where there is co-creation or co-authorship to some degree.
And by the way, this feels like it's promoting the progress of science and the useful arts, big time. It feels like it's really doing what the statute says it wants to do, what the constitutional clause says it wants to do.
It certainly doesn't feel like you can stop it. It certainly doesn't feel like you can legislate it out of business. It certainly doesn't feel like you can do protective tariffs or protective taxes or a huge number of things to outlaw it. If you do that in any country, US, I think Italy tried to do that or is trying to do that, all of the creators go elsewhere. They just say, hey, the online system will allow me to plug in from Canada, will allow me to plug in from Mexico, anywhere in the world. Now I can get Wi-Fi on a dish via the Starlink system from Elon Musk's company. I'll just get that in the middle of the desert. On top of my RV, I can drive around. I can be completely stateless. I can be a perpetual traveler. I mean, think about that. It's almost like I'll avoid, as a creator, I'll avoid whatever territorial laws are trying to outlaw what I do. That may require a move to another country. But I think that's kind of the way this disruptive element thinks about things. Like, you're never going to stop me. You're just not going to stop it. So the real question becomes, how do you regulate it? If you can't stop it, how do you create a system that balances for those who are creating the ability to say, I like this. This is okay. This is another form of publishing system. I like to be published. I want my work to be known, assuming that the person does want their work to be known. Is that something you can bake into a system that really wasn't designed initially as a publishing system? The internet.
You mean Stability AI?
Yeah, Stability AI and all of these other tools weren't pursued as, we're going to allow for a monetization function for those who enroll. Like, you can imagine, in theory, Stability AI can say, just enroll and become one of our authorized authors or authorized content creators, whatever word they want to give to the notion of a creator or co-creator, and we'll track and compensate. Whoever does that could well have an extremely valuable legal business that is viewed as, there is a way to do this. It does require a micropayment approach. And there are people that do this with various podcast publishers that actually do track the usage of the podcast and distribute royalties and that sort of thing. So there are precedents out there for a publishing model, but Stability AI, ChatGPT, all these other companies that have hit the ground running really fast, correctly, as you say, since about 2021, they were, researching this stuff for years earlier. It really became public or publicly known. They'll probably be public companies too in 2021. And they've gotten huge valuations because they're viewed as the next new thing that are going to change things throughout the world in a really big way. The litigation is kind of a speed bump in the road. It's not really, the class action case, I guess, is pretty novel. I don't think there have been very many copyright class action cases in the history of the Copyright Act. There may be like less than 10.
Right.
And it's a class action law firm. It's not really a copyright or intellectual property law firm. I'm sure they have litigation funding. I'm sure it's not a pure contingent fee model. And it's a big question. How do you come up with an approach? And you could see Judge Orrick must be scratching his head saying, you've got 3 or 4 plaintiffs. Yes, they have, 10 or 12 works each. Maybe that's 30 or 40 works that have to be looked at. But you're asking for class action treatment for the entire world of registrants. Right. That's a huge number of people. By the way, that's not even most of the internet. One calculation I saw recently is that's like less than 1%.
Really?
Yeah, really? Very, very low number. In other words, if you look at, do these tools have a substantial non-infringing use? A substantial non-infringing use, they're being used for other purposes. 99% of what they're scraping is not registered as a registered copyright. Now, it may well be protected by copyright, but the registration is not perfected. And they were worried that the case was going to get thrown out for the lack of registration. So they decided to say the class is only registered copyrights. But that's a very small sliver of what's currently the content on the internet. Most people don't register. They find it to be a hassle, and there's a deposit requirement. I mean, it should be a lot easier. The Copyright Office does allow a lot of online stuff. There is a fee. Obviously, if you want to be part of the class action, you've got to register because unregistered works are not going to count. But in general, if you look at the big picture, it's less than 1% of all that content that's there. So do they have a ground just to say most people are probably okay with what we're doing? They don't think about their work as something that they want to get a royalty from per se. They don't think that way at all.
Yeah. Also, as I said, if I write a book and you create a derivative work from my book, that's one thing. But if you and I write a book with 15 other lawyers, it's a little different. And if we write a book with 1 million other lawyers, it's really different. It loses its human quality, which seems to be important to the Copyright Office. Only humans are entitled to copyright. And by the way, by the same token, shouldn't we say that only humans can infringe? Not computers, not monkeys?
Well, the humans that are controlling the computers are viewed as the infringers. They just happen to be using these massively amplifying devices to do it. But I would be really interested, to me, when we're really going to more fully understand what actually happens at a technical point of view, is if there's ever a trial and if there's ever an expert witness explaining exactly what they do, we're going to get a very big tutorial, as the court will, of here's what's actually happening in this process of abstraction, digestion, diffusion,
well,
what they're calling
both of the complaints purport to give us a tutorial, a short one, but both complaints give us tutorials. The Anderson case talks about the spirals and the noise on the image and removing the noise. And the Google Images case gives a more elaborate verbal account of how the thing works. So they try to do that. Do you have any cases like this?
Well, the original software cases that were out there, the original notion of is object code protected, given that it's machine generated, right? Object code is generated by a computer from the source code. So back in the 1970s, literally the question of the day was, well, what's actually happening? Is it a derivative work? Is it a copy? Is it a specially created work? Like, what is it that's happening? And the courts said it's basically another version of the source code. The machine generation is just sort of transforming it in a way that doesn't change the authorship. And a lot of people sort of scratched their head and said, really? Is that really true? And that's kind of what has been agreed upon, that the owner of the source code copyright is the owner of the object code executable file. And that's the way it goes. And in many ways, that is an analogous point to this current situation, which is what's actually happening here at a level, like what's actually going on.
That's interesting. But of course, AI could read your source code and my source code and 40 other source codes. And then it could decide which compiler to use. And it could merge all the results of all the compilers and improve the product, maybe.
So let's play this
code. When they write code these days, aren't they doing that?
Yeah, I mean, let's play this for a second. It's short enough.
Stay tuned for part 2 of this episode of The Valley Current.